Mr. Griffin, the gentleman from Arkansas, recognized for 5 minutes.
Thank you, Mr. Chairman. I want to follow up, Mr. Horton, on your testimony. You mentioned the studies that deal with first to invent versus first to file. And I think you mentioned Mr. Mossenhoff's study. In your testimony, you refer to Professor Lemley's study as well, and you indicate that it suggests that the current first to invent contests are more often used by large entities to challenge the priority of small entities and not the reverse. Could you, and I see that you're citing a Hastings Law Journal article. Could you talk a little, could you talk a little bit about that data, or are you familiar?
I don't believe I cited the Lemley study in my testimony. That's the reason I raised my eyebrows. We did speak in my oral testimony about the Mossenhoff study.
Okay. In your, I'm just looking at your,
okay.
In your statement, I'm
yep.
sorry.
So the question, just so
if you could elaborate, if you could talk a little bit about, if you're able, if you're familiar with that data, if you could talk a little bit about the Lemley study and maybe that data versus the Mossenhoff study. What sort of data was used to write that Hastings Law Journal article?
Well, I'm more familiar with the Mossenhoff study. If you want me to comment on that?
Sure, sure.
Okay. What Gerald Mossenhoff was attempting to look at is the frequency where the small inventor really did, in fact, was successful in the patent office in a challenge contest over who was first to invent, the interference proceeding, essentially. And I think one of the things they were keyed in on is it's not simply big versus small. It's a question of who was first to invent, obviously, but it's a big question of proofs. An interference proceeding, if you haven't been in one, it's very akin to a litigation. It takes a great deal of time, worse, as Judge Michel would say, but it's very lengthy, very expensive, and in all intents and purposes, the same. So the small inventor is at a significant disadvantage, financially and otherwise, to go up against the bigger companies. Not surprisingly, therefore, they win less than 50% of the time.
So to a large degree, it's simply a matter of who can fund the litigation and who can't.
Yeah, because you're looking at proofs. Who can come up with the proofs and substantiate? It's not whether I invented it first, it's can I prove that I invented it first?
The judge mentioned the concept of balance here, and from what you've written and from the testimony I've heard, the first-to-file, a change to a first-to-file system may benefit small businesses or smaller inventors. What impact, if any, would it have, other than maybe balancing things, what impact would it have on the bigger companies? Is it a more balanced approach, or does it just turn the advantage the other way?
You know, it's funny you should ask that because, and Dave can comment on this as well, I'm sure he feels very similar. We've been operating for years as if that were the system that the U.S. was using. Because we have to. We're global companies, so big companies that export, we have to play that way because it's all about who gets to the office first. We stopped thinking about who was first to invent and keeping detailed, recordings, inventor notebooks that they keep. We stopped playing that game because we figured the safest way to win every single time, everywhere, is to get to the office first.
Congressman, if I could add,
Yes, sir.
I don't think it's so much a question of who wins these long, complicated interference proceedings. I don't challenge the statistics that have been mentioned. But from what I understand, it's more a question of who can fund early filing. And apparently, there's some evidence, I don't purport to be able to weigh it because it's not all on the table in front of me, but there's some evidence that some universities, some smaller entities, have difficulty in funding the early filing of the patent. So I'm simply saying I'm not against first to invent, first to file, and I'm not for it either because I don't know enough about it. My only pitch is that the Congress, before it makes the final decision, should assure itself that it doesn't unduly hurt some of those universities and smaller entities. I'm not saying it does, I'm not saying it doesn't, but it's worth finding out.
I'll just mention one caveat that to the extent it's a question of cost, obviously the S-23 is looking at that issue and creating even a micro entity status that gives them a full 75% cost reduction to make it even more affordable for them to afford that early filing.
Sure. Just one, you had something to say.
Yes, I You know, the statistics I've seen are similar to the study that Mr. Horton refers. The only caveat I would say is I think it's important that it have, for small businesses, that it have a prior user right, because if you actually can show you used it first, the fact that somebody else patented it before you did, you're still protected.
One quick follow-up, if I've got a second. I just want, if there is additional data and additional empirical studies that aren't mentioned in your statement or you didn't mention in your testimony that would help us and fill in some of the gaps or maybe that the judge is referring to, if you could get us that information, those citations, would be real helpful.
Be happy
Thank you,
to
Mr.
do so.
Chairman.